of TCC Judgment 112 宪判 18, 2023, Case on Election Recounts. High notes, the Taiwan Constitutional Court, TCC, declared Article 69, Paragraph 1, first sentence of the Public Officials Election and the Recall Act, herein after the Election and the Recall Act, unconstitutional. The TCC ruled that within the scope of the provision limits recounts to specific election, the provision's differential treatment did not pass intermediate scrutiny, thus violating the right to equality. Background note: in 2022, the petitioner Gao Chen-ye ran for township representative of the first electoral district of Xinfen Township, Hsinchu County. The township should elect 5 representatives, but the petitioner came in 6th place by the margin of 2 ballots, within the margin of 0.3% of valid votes. The petitioner filed for a recount with the district court, but was dismissed because the recounts for township representative election are not stipulated in the Election and Recall Act. After an unsuccessful final appeal to Taiwan High Court, the petitioner filed for constitutional review, arguing that both the disputed provision and the Taiwan High Court's dismissal ruling were unconstitutional. The TCC admitted the cases and ordered sua sponte for preliminary injunction to prolong the safekeeping period of the electoral list and the ballot via TCC Order 112 Xianchen Taiwan 2023. Summary of the judgment holding 1. Article 69, Paragraph 1, first sentence of the Election and Recall Act stipulates if the difference in vote between the top 2 candidates in regional election for district member of the Legislative Yuan, governor of a municipality, municipal mayor, or the governor of the county and the city, or between the 3rd and 4th place candidate of indigenous non-member of the Legislative Yuan is within 0.3% of the total valid ballot. The candidates with the second highest vote for district member of the Legislative Yuan, municipal mayor, or county city governor, or the candidate with the 4th highest number of votes for indigenous member of Legislative Yuan may apply to seal all or part of a list of electors and ballots within 7 days after the polling day to the court with jurisdiction prescribed in Article 126. The ballot recounting of the sealed polling station shall be completed within 20 days, and the result of a recount shall be notified to the Election Commission in charge. This provision excluded those who came first in the losing candidate of election not listed in the list provision from filing for the recount with the court if they lost within the margin of 0.3% of the valid ballot. Within this scope, the disputed provision is unconstitutional as it violated the right to equality under Article 7 of the Constitution. The legislature should review and amend the pertaining regulation as soon as possible. Before the amendment, all losing candidates with the highest votes and those within the margin of 0.3% may, within 7 days after the polling days, apply to the court with jurisdiction to seal all part of the polling station's elector list and the ballot and complete the recount of the sealed station within 20 days. 2. Taiwan High Court Civil Order 112 Shenkang 1, February 10, 2023 shall be quashed and remanded to the Taiwan High Court. The rest of the petition is dismissed. The reasoning 1. Level of scrutiny. In principle, legislators shall have a certain extent of legislative discretion when drafting election laws and their remedies, so long as the legislation meets the requirement of equality under Article 7 of the Constitution. Considering that the elections are of great significance to democratic parties, and that the Constitution protects the people's electoral right, if relevant laws were designed to have differential treatment, the goal of this differential treatment should be important public interest, and the classification should be substantively related to the goal. This is called the intermediate scrutiny. Second, review of the TCC. The disputed provision stipulated the court adopted a recount procedure to ensure the accuracy of the election results, maintain a fair election, and protect the people's right to hold public office. For all democratic elections, resolving electoral disputes quickly is also of important in public interest constitutionally. However, the disputed provisions have created a differential treatment in recounts between the election of indigenous district members of the legislative yuan, municipal mayors, and the county city governor, and that of the other public official election. This classification is based on the type of the election. However, the goal for this classification is not expressly provided in the racial ledgers of the disputed provision. Furthermore, all elections required by the Constitution and all law shall be an important segment of democratic parties. They are all of the common goals mentioned above and are no different from each other, even though different in level, central or local, and the nature, representative or administrative leader. The classification stipulated in the disputed provision is inappropriate and not of important public interest. Saving on judicial resources and reducing administrative costs are also not of important public interest in this respect. In terms of the relations between the adopted classification and the legislative purpose of the disputed provision, the classification has factually deviated from its purpose instead of substantively related to it. Therefore, the disputed provision does not meet the requirement of the right to equality under the Constitution.